So you just got the case and you're looking at all of this and you're thinking, what am I supposed to do with all this material? There's complaints and answers, indictments, bills of particulars, case law, common law, statutes, maybe if you're lucky, and then all of the witness affidavits, expert reports, jury instructions. If you feel overwhelmed, we're here to help.
So Ben, you got this huge file in front of you. Like you just said, all of these parts, and you've got to turn this into mock trial magic, right? You got to make this into the best case possible, entertaining procedure, everything else. So what are we supposed to do with all of this? How are we going to work our way through a new mock trial case?
The first thing I like to start with is what we as attorneys call pleadings. Pleadings are just kind of preliminary documents. In a civil case, the pleadings are the complaint, which the plaintiff files, the plaintiff being the party that thinks they were wrong, that thinks they need some money. They file a complaint against the defendant. The defendant is the one who maybe did something wrong, maybe they didn't. The defendant files an answer, and the answer either admits or denies the factual allegations in the complaint. After that, you may have some other motions. Those could be considered pleadings. Not normally in a mock trial case. You might have some motions in limine. Those are about evidentiary matters.
All right, you do civil, I do criminal. So, yeah, I mean, when you have a pleading in a criminal case, what we're talking about usually is the indictment, which is the prosecutor went to a grand jury and said the defendant did some bad things, and so we should charge them with crimes. So there's not going to be a complaint answer kind of back and forth like you're going to have in the civil world. It's usually just indictment, bill of particulars, which is just a breakdown on a more fact specific level of what the defendant did to be charged with a crime. And then you might have some motions in limine, just arguing about evidence, exchanging of documents for discovery. But I mean, that's usually about it for pleadings. I guess my question to you, Ben, is but why would we start there? That is not fun, exciting stuff, right? I mean, that's not the witnesses, that's not the reports, that's not the stuff that's going to get you jazzed. Why do you want to start with the boring pleadings?
Because the pleadings tell you what the case is about. If you just read affidavits of witnesses or expert reports, if you do it long enough, if you take a bar exam, if you're a lawyer, you might be able to spot an issue and say, okay, this could be a tort or this could be a crime. But if you read the complaint or the indictment, the pleadings before you read the facts, there's going to be no question. You're going to know, okay, this is a robbery case. Okay, this is a wrongful death case. You'll know what it is before you get into the facts. That way you can kind of focus on the facts that are important easier.
If you don't know have a roadmap going in, you're not going to know what you're looking for. And so you're lost. You're wandering blind in the woods, and you may have facts in front of you, but you don't know whether or not they mean anything. So the pleadings are going to let you know this is what they're saying. This is how they've denied that or they disagree, or in the criminal case, what facts are going to be important for the crime. After that, though, once you've got your baseline map, I do jump right to the affidavits and the reports. Then you get the affidavits, and then, I mean, I'll usually start with fact witnesses, right? People who aren't experts, so that I can get kind of boots on the ground, eye level witness testimony. I don't necessarily start with, say, the defendant or the party. I just kind of go at whatever eyewitnesses I go through. Do you have any recommendations for that?
No, I just start with the first fact witness. I do the fact witnesses first, but I just start with the first fact witness and I just plow through them. You tend to, especially as mock trials get more and more sophisticated, you tend to find parties, defendants, plaintiffs that are less bound to written statements. So the party may not have an affidavit. Maybe they have a deposition, which is different. An affidavit normally contains all of the relevant facts, while some cases have depositions that are question answer format. So you only have sworn testimony to the questions that were asked and leave some room for interpretation. So trying to get a boots on the ground perspective, very baseline perspective from the party especially in cases where they are not tied to a universe of facts. Maybe they have extra facts that you don't know about. That can be extremely difficult because it could be a tainted picture. It could not be a complete picture. And you may have to fill in the holes with the party just based on the other affidavits that are out there.
And then once I moved on to the experts, that's usually pretty nuanced, right? You've got medical examiners or you've got somebody who's an economist, right? I mean, that's usually more number heavy game. And so that's why it's also going to be important to have read the pleadings because, in a civil case, you know what these are talking about. This goes to damages or causation, or in a criminal case, usually dealing with things like fingerprint analysis or blood spatter or psychologist or an ME who did an autopsy. And if you don't know what you're looking for, then that's hard. But all of this, I usually read through them once, and then I'm going to go back. And why might I want to reread the affidavits after I've gone through the first time, Ben? What am I going to do next?
So the second time, you're going to identify facts from the first time that became relevant when you read the materials. So let's say, for example, you read the first affidavit, the witness talks about the color of a vehicle. The first time you read it, you may not think the color of the vehicle is very important. But as you read more and more of the fact witnesses, you realize every fact witness is talking about whether this vehicle was red, blue, or green. So now I need to figure out, okay, which witness knows what? What's the truth of what's going on? How does this fit into the case? So the second time and the third time and then, you're going to think about these different facts between the witnesses so you can parse out who's telling the truth and who's lying.
And as I'm going through these affidavits, I'm usually going to arm myself with two different color highlighters. I'm going to say, okay, this is for one side. This is now that I have a bigger, broader picture, bird's eye view. This is for the other side to try to get an idea of the facts that if I'm the plaintiff, I want to prove my case and the complaint or the prosecutor and prove the charge versus defendant. And then ultimately, I'm going to take that information and make a T-chart. So do you do that, Ben? Do you still use highlighters and make T-charts and that kind of stuff?
I sure do.
And what are you putting into your T-chart? I guess you want to explain that?
Sure. So a T-chart is, if you can imagine a T on a page, you've got a line straight across the top horizontally and then down the middle vertically. On the left side, you put all the facts that are helpful to the plaintiff or prosecution. And then on the right side, you put all the facts that are helpful to the defense. They work best if you include line numbers or paragraph numbers from the affidavit or report that you're pulling the information from. That way, you can go back to it and reference it quickly.
Once I've made these, I'll come back to them, later when we start trying to have to worry about cross-examination, direct examination, what witnesses I'm going to call. We're forming a theory. These are nice, easy charts you can go to say visually, wow, that person has a whole lot going for them on the plaintiff or the defendant. And it kind of helps you guide your theory or your structure of what witnesses you want to call. And it makes for easy cross fodder, to say, look, these are the parts that hurt or help on this situation. And you've got your line numbers. You kind of did some work ahead of time. So that's how I always go through my affidavits and reports. It's what I do in the real world, and it's what I'll do, when I'm preparing a mock trial case too. So once we get through affidavits, reports, evidence, if there's pieces of evidence, and we've sectioned it off to which side and party they're going to apply to, what do you do next, Ben?
Then, and only then, do I go back to the case law.
And why? I mean, I agree 100%, but why only then do we go back to the law?
A lot of times we talk about analysis. Analysis is really important to attorneys because that's applying facts to law. That's the argument. So now you have the facts. It's time to look at the law. You need to look at the statutes and the case law in the case to see where your facts fit into the elements or the factors that you're trying to prove to meet your burden or to rebut the burden.
Yeah, and then I'm going to go through, and most of the time the case law is sectioned off onto certain things, right? This goes to causation, right? And I'm going to figure out, okay, how does that limit, when I have my T-charts and it's sort of the best case scenario of everything I could get out on either side and figure what's going to work, what's not going to work, what's limited, what could become objectionable, so that I'm starting to plan, okay, is this witness worth calling? Because they have a lot of objectionable material, even if it's juicy, it may never come out. And so then it may not be worth calling that. And that's going to factor into your case theory. and, witness calls and sort of the gamesmanship when you have to figure out if you can even get any of this stuff out of the witness onto the record and more importantly for mock trial into your scoring bank. So that's how I'll look at it as well. And then ultimately, once I have all of these pieces, what's going to come in, what may not come in, what's my risk and reward, I'm going to try to make a timeline of the case.
I make a timeline for every case I have, real or fake. I think it's the most important tool that you can have. If you have a timeline and T-charts, I'm a firm believer that if you do mock trial long enough and you have those two things, you can put on a colorable case against another team. Now, you may not win, against the most polished teams, but you're going to do a really, really good job if you have timelines and T-charts with a little bit of experience.
What sort of things are you going to put on your timeline to make it successful?
So my timeline is going to include if I'm the burden carrying party, normally the plaintiff or the prosecution, I'm going to flag every time I am proving an element. And the reason I'm doing that is so if I get a relevance objection or something like that, I can say this is relevant because it goes to this element. If I'm the other party, if I'm trying to beat the prosecution or the plaintiff or the burden carrying party, I'm going to put what's rebutting what element when that happened. Other things that are important on timelines are when someone knows something. So about the car, for example, the color of the car, when did that person see that car? Is it possible that they saw a different car and they thought it was the same car? Maybe my timeline will show that when this witness says they saw that car, well, another witness that I believe is more credible saw the real car across town. So I'm going to line up different discrepancies between witnesses. Hopefully, the discrepancies are not between witnesses that I'm calling on the same side. Hopefully, these are things that are going to come out on cross-examination of the other team's witnesses. But I'm going to flag those kinds of things. So you're looking for basically two things. One, how you're proving your case or rebutting the other person's case. And two, inconsistencies that you're going to exploit on cross-examination.
I mean, ultimately, my timeline becomes my mechanism to, when we start talking about theory and themes and those sort of elements that are going to help a common thread go throughout the case and then help it score, you can map it all out. What does this witness bring to the table? When do these events line up? And most importantly, how am I going to communicate this to my judges who are scoring me and want to be able to know what happened? The easiest way to score well in a mock trial round is to make sure your judges actually understand your case. And if you don't understand all the players and you don't understand how the facts fit the certain events, or when did this expert get hired, you're not going to be able to explain that to the judge. They're going to feel lost, and then your scores go down. You make them feel smart, your scores will go up.
That's a great example. There's a good story about this is with the expert specifically. I had an expert once in a fake case. This is not real. Thank God. By the end of the story, you'll think, thank God this isn't real. I had an expert who said, in classic expert fashion, I came in after the fact. I don't have personal knowledge of the facts of this case, which is fine. So I reviewed certain affidavits to prepare for my testimony. I reviewed, person A, person B, and person C. And then you go through the entire report, and he signs the report on, let's say, April 1st. Well, then I read the affidavits of the people that he said he reviewed. And one of the person's affidavits he said he reviewed was not drafted until a week later. So that became a huge cross point because, and let's be real for a second. Let's pull back the curtain. Okay. That was probably a drafting mistake for the case writers. It wasn't, a nationally recognized case writing committee that put this case together. Weren't super sophisticated. So they probably made a mistake. But I definitely exploited that because I made a timeline and I figured it out. And the expert was not ready for it on the stand on cross at all. He had no good answer for how he was relying on an affidavit that didn't exist at the time he wrote his report.
Yeah, that would not have gone well in the real world for that expert. When you're trying to do mock trial and you're trying to show the judges, I know this, it also is going to help you if you have that bird's eye view of the case because you'll see how all the pieces fit together. And if you get stuck in your vacuum, and that happens a lot in mock trial, right? I direct witness A. So why should I care about witness B and C? It's because if you have the bird's eye view, one, you can help your team. But two, you're able to pivot and respond. And as you're more responsive and you show a command of the facts, your score will go up. And so you want to make sure you have that bird's eye view. Don't lock yourself into the vacuum that is your particular witness. Make sure you understand that. And even for witnesses, as Ben's point shows, you need to make sure that if it says you refer to some affidavit or report, make sure you read it. Even if it's not in your particular report, if it's an underlying fact, make sure you know it so that you can respond and get caught with your pants down, because obviously that's going to hurt your score. So, in review, when we get that first case and we're excited, try to break the temptation to just read from front to back. Make sure you have a strategy and know what to look for. Start with the pleadings. They're not exciting, but they're really important to guide you so that the rest of the file makes sense. I've been on a case committee. I can tell you we start with the pleadings, so you should too. Once you're into the affidavits, read them a couple of times. Make your Tchart so that you know, what does this witness bring to the table for both sides? And as Ben pointed out, you're probably going to want to put line numbers. You'll use them later. Go back to the case law. Now apply those facts to the law to see what's going to work and what's not going to work. And then finally, make the case timeline so that it all has a bird's eye view to fit together.
Okay, so now you know how to read a case. That's how we do it every time. And it's not that we get good at this, so we stop doing what we're preaching. We practice what we preach every day in our professional lives and our mock lives. So you should too. After this, you're going to want to start looking at the witnesses. How am I going to make this case come to life? We'll teach you that in the next episode.